Right now, thousands of H-1B applicants are panic scrolling Reddit, asking the same question. Is the lottery dead? Will only $200,000 per visa? Well, today we are going to separate fear from facts and what litigation could change before lottery season even begins. So, friends, welcome to Immigration Talk Show. I'm Nipasa. I'm going to be your host for today. And I'm very excited that we are going to have none other than Attorney Justin Rivera with us. So, without further ado, help me welcome him back to this show. Hi, Justin. How are you doing today?
Well, happy 2026 to everybody. I'm good. Looking forward to discussing some of the latest changes and issues going on with the H-1B visa and other visas as well. What are you doing? You done? No, the video is not working right. I love you, Dad. Love you too. Do your best, Dad. All right. Wow, you're a good typer.
Sorry about that. I'm facing some technical issues, but I hope I'm audible now. But yes, I'm excited for today's show. Today we're going to have none other than Attorney Justin Rivera from Wasden Immigration Litigation talking about something very important. And Justin, this is going to be our first show of the year 2026. I know January has been super busy for you. And I think all I can say is, if I'm very audible or not audible, could you please write on the comments if you all can
Yes,
hear
you are.
me? Okay. So, all right. So, thank you so much, everyone, for joining us. Everybody's been asking this question, as in, like, what's going to happen? Is the lottery really dead? If you scroll through Reddit, it's also, people asking the same question: is lottery dead? Will only $200,000 salaries get picked? And this is a question that most folks are also having in their minds. And if you two are having some of these questions in your head, do write to us. You can comment wherever you're watching. We're streaming live right now on YouTube, LinkedIn, Facebook, X, and on Instagram. You can also connect with us. And yes, don't forget to subscribe our channel. Our handle is at Immigration Talk Show. So do employers really have to pay this shocking $100,000 per visa now? I think we are going to try to separate fear from facts in today's session, and Attorney Justin Rivera is going to help us with that. So, Justin, like I was saying, this is our first show today. How's it been for you this 2026 so far?
Yeah, thanks for having me. It's been busy. I think that obviously we're seeing the second year of the Trump administration's kind of proverbial assault on legal immigration. There's definitely, going to be an uptick in, and we've already kind of seen it play out. FDNS site visits are increasing, as are apparently F1 student site visits as well. Our office was actually just made aware this morning of a client that actually has a site visit in relation to STEM OPT employers and employees. And so I think that's something you're going to see a lot more. I think the ramping up started close to the end of last year. And I think you're going to see that really play out over the span of this year. They're out in force looking for opportunities to revoke H-1B petitions. And also, potentially remove people from the STEM OPT program. So, on top of what we're dealing with in terms of the shifting, H-1B in terms of the, $100,000 fee and now the new weighted lottery system. I think that, absent some pretty good litigation, we're in for a very interesting year, a very interesting year that I think if you're able to potentially navigate things well and staying well informed, you'll be okay. But if you're not, then I think you're going to be kind of caught by surprise with the level of difficulty that there is now in the H-1B program. Okay, it's not working again.
All right, Justin, thank you so much for that. Still facing some issues with my video, but if I'm able, maybe if I can go ahead and ask the question. Are you there, Justin?
Yeah, I'm here. Sorry, my mic was muted.
Okay. So my question to you, Justin, is why is the H1 lottery being seen as a rich people visa now?
So the lottery itself is a process by which individuals are registered by employers who want to be their petitioners and submitted into the H-1B visa lottery, so that a certain number, I believe it's 85,000 individuals, can be chosen. There's a normal cap and an advanced degree cap. Now, since the lottery's implementation, the idea was that there was a level of equivalency to the system. An individual's registered that, is going to eventually be maybe a senior level is the same as an individual who is registered that is an entry level employee. That information wasn't pertinent to the lottery. What was more so relevant was just that the individual was sponsored, the company paid the registration fee, and then the individual, goes in either with one opportunity. If they're bachelor's only, or if they have a master's cap, they have a little bit of an advantage in the fact that they have a higher probability of selection. So what's changed now, and I guess this idea that it's more in terms of a rich person's visa, it's more of a rich company. What's happened now is, USCIS has decided that they're going to apply a sliding scale to the H-1B lottery, where they're going to say, based on your wage level, you have a set level of, for lack of a better word, ping pong balls, that are going to be entered for your options. So whereas before, if you were filing for someone that would eventually have a level one wage, then okay, you have a level one wage. It is what it is. You have the same, odds as anybody else. The change has become now that the wage level is a variable that's taken into consideration with how many ping pong balls you get in the lottery. So this means a level one wage is entered one time, a level two wage is two, level three, level four times. So that means that an individual who is sponsored by a company that has the financial means, capacity to sponsor that person for a level four wage can enter that person in with a higher probability of selection than someone that is only being entered in once. Now, that doesn't mean that a level one wage is not going to be selected, right? It is a lottery. But increasing the odds of selection obviously is beneficial for the individual and the employer because it increases the certainty of selection. So that means now you're going to be faced with a circumstance where companies who have the ability to pay the level three and level four wages without really having issues are going to have a weighted advantage. And it was actually kind of interesting because to give you guys a kind of peek behind the curtain professionally, AILA is the American Immigration Lawyers Association, right? So AILA handles immigration matters, and there had been this chatter for some time that AILA was thinking about actually filing a lawsuit against the lottery system. And while the preliminary discussions were going on, there was actually people who stepped in and said, individuals who are in AILA, who are attorneys, and said, well, hold on, my client doesn't necessarily want this to go away because my client is a large company and my client has the capacity to pay these higher wages, which in turn increases their ability to garner top talent. to come in on an H-1B visa or convert from an F-1 to an H-1. So as a result of that, it looks like that litigation's dead in the water. That could be subject to change. I'm not a high up person in AILA. I'm just a member. But I do know that there is now discussions that, well, the lottery could be good. Well, if the lottery is good for the large companies, it's obviously not going to be good for the smaller ones, because the smaller companies that don't have the capacity to pay those higher wages are likely going to have to settle for filing level 1 or level 2 wages, lowering the probability of the individuals being selected. I think that, the far-reaching implication of this is you're probably going to have less individuals submitted in this year's lottery. And that's going to be twofold. You're going to have the fact of the matter that individuals are probably going to be less willing to sponsor a higher number of individuals when they know that the probability has lowered of them being selected. And the fact that individuals outside the United States are now subject to the $100,000 fee. So, if you're a company that's likely going to say, I have 4 people that are great candidates, 2 of them are in the US and 2 of them are out of the United States, you're now doing calculus and saying, okay, what level can I sponsor these people at? But also, am I willing to foot the bill on $100,000 to bring this person into the US? I don't think you're even going to see many large companies willing to do that. I think, truthfully, unless this person is incredibly unique and specialized, they're not going to bother to pay the fee. And at that point, you begin moving out of the H-1B conversation anyway and into the O-1 visa conversation. Because why wouldn't you sponsor that person for an O-1 if they can be approved and you don't have to pay $100,000? So I think overall, my guess is this year's lottery, if it proceeds with the current iteration of the weighted system coupled with $100,000 fee, I think you're going to see a pretty big drop in registration numbers. I'm not sure how cataclysmic that drop will be, but I think that it will be sizable. Would be my guess.
Justin, and it's crazy because that way it'll not be like a proper lottery also even anymore. It'll just be like a for a preferred number of people. So, like you said, so many other low-waged companies are going to be suffering as they cannot be taking in workers who they have to pay low wages. So I know. And then when you talk about this consultancy model, also, if you look at it, it is also being impacted by this lottery system, the weighted lottery system. So if you can also tell us how.
Yeah, I mean, well, the part for consulting companies is the fact of the matter is their work is project based, right? So a lot of times, if you're a company that is a consultancy and it's March, you may not have an individual lined up on a project that's going to be available on October 1st. Also, that project could change. That was why beforehand registration occurs, and afterwards there's selections. You have some time to file the H-1B, find a project if the person's not already on one, and file. In this circumstance, you're seeing a situation in which all of this information is going to need to be provided up front, right? Because we have to establish the person's wage, which means we're going to have to establish where the person's working and what they're going to be getting paid. So what that does for a consulting company is it drastically complicates things, because now you're in a circumstance where you're saying, all right, well, it's March and I need to lock down where my guys or gals or my team or whatever is going to be on October 1. So do I have that project locked in or not? If I don't have that project locked in, am I just filing for the project that they're on with the hopes that it gets extended? What happens if my case gets selected and I need to actually change the information? So these are all going to be things that are going to be dealt with by consulting company employers. Truly, something that I think hasn't received a lot of attention, is that the Small Business Administration recently has again adjusted laws that are to basically say that they now want to bar green card holders from participating in the small business loans, being able to be eligible for these small business loans. Doing that obviously makes it harder for individuals to start companies. People can gain capital from other ways, but it still kind of blocks it. And my overarching theory is that for whatever reason, because I don't think the justification is that it's beneficial to the economy, I think for whatever reason, the government is now firmly aligned with the idea that they want to curtail and potentially eliminate the ability for startups and small companies to use H-1Bs if they are owned or operated by legal permanent residents. Um, what's also a difficult thing here is that, there are a lot of companies that, they're probably 40 to 50 employees, maybe a little bit more. They do create jobs, but they don't have the same level of revenue as, a Meta or an SAP or a Tesla, like these massive multinational companies. And so they're kind of being gamed out of the system. For the consulting companies, I think that I would be shocked if there was not a mass surge of FD&S investigations right around October 1st, because I think part of this policy change was done to make it harder for consulting companies, but it also is probably set up so that if a consulting company October 1st has provided information about registration that a project that someone was on, and they're no longer on that project on October 1st, it opens the door for pretty easy DHS investigations into those cases, and potentially revoking those cases. So that's how I think that the consulting model is going to be impacted, and I think it's going to be fairly negative, to be honest. I wouldn't be surprised, like I said, if you saw a drastic reduction in the number of people that are registering this year.
Right. And like you were saying, if people will be extraordinary, then they'll obviously go for O1. So let's see, maybe like you said, we will have, a very less number of people registering under H1B this year. I think at least we are expecting that. Let's see what happens though. And to go on, Justin, I have another question. What does this lottery mean for multiple filings, future multiple filings?
I'm sorry, you mean that multiple filings is in multiple people filing for the same individual?
No, yes, that too. But I think we already have solved
Yeah.
that problem last year. So now about it's going to be about once the term is over, how about filing again after that?
Oh, subsequent extensions and all that kind of stuff. I got what you're saying. Yeah, I mean, once you're through the looking glass and you get past that initial H-1B petition, you're going to be able to file an extension or amendment or transfer. Now, what the government has done to preclude people from gaming the system is they've already put out within the new rule determination that if you file for a level 3 wage, and October 1st comes and goes, the person gets selected, approved, H-1B, and then November you file an amendment to lower that wage to level 1, the government is going to say on its face that's fraudulent, right? That you game the system in order to increase the probability of selection, and you're now amending the petition down so that you can pay a lower wage. So I think that they're going to look very harshly at those cases and possibly deny them. Now, if we stretch that theory out and say, let's not just say October 1st, but let's say 3 years from now, you're coming up for an extension, the employer has you at a level 3 wage. Well, if they try to drop you down to level 2, it wouldn't shock me if USCIS attempted to employ that exact same argument and saying, wait a second, you had this guy at level 3 and now you're trying to go lower and he has 3 years more experience with the company. What's the justification? And what I think that is going to do is it's going to basically put employers on a path where um, if you start out having somebody with a high level wage and they remain on that high level wage, right, it could dissuade people from wanting to actually sponsor them at all. Um, so I think that, yeah, I think that for the multiple filings, I think what's going to happen is the wages that's selected is going to be high and it's going to remain high. Otherwise, I think you open the door to scrutiny to potentially having your case revoked or having a denial.
Right. And what about, employers? What is going to prevent employers from inflating salaries on paper if weighting is based on wages?
Well, like I was saying, it's not possible for them to long term game the system. So let's say you inflate the lottery selection and the person begins working with the company. If you then don't pay the wage, you open yourself up to a DOL investigation. The employee themselves could report you, or you could be randomly audited, which is occurring at a higher frequency. So in that circumstance, if you try to game the system that way, you open the door for DOL to come in and actually disbar you, meaning you're removed from the H-1B program. So I think that, there's always bad actors in any sphere. And I wouldn't be shocked or surprised if there were individuals or companies that attempted to game the system in that manner. I expect those kinds of companies to be exactly who FDNS is planning to target around the first month of the new fiscal year when the H-1Bs become active. So I would not be shocked. I mean, I'm sure I and other attorneys are going to spend the next 2 or 3 months screaming from the rooftops not to try to game the system, not to try to do anything that could negatively impact your company. And there are just those actors that are simply just not going to listen. And those people are probably going to be caught, and hopefully they're weeded out and removed from the program.
Well, very well put, Justin. Thank you for that, for taking up these questions. And folks, I wanted to say that, we are streaming live right now on YouTube. So don't forget to check us out. We are at Immigration Talk Show. And also check out Attorney Justin Rivera. You can check them out on LinkedIn as well. They are Wasden Immigration Litigation. And I'd like to say hello to Richard and Silvermine. Thank you so much for joining us. Also, Rajendra, Sid Mohan, good to see all you folks with your questions, and we're going to take them up. So let's pick up this one from Richard for now. Richard is on YouTube asking if the weighted lottery disproportionately disadvantages level one and level two wage rules, what legal exposure do employers face for continuing to hire international graduates?
So I think that it does disproportionately affect level one and level two, but honestly, the level one is the one that's most drastically affected, right? The fact that you are down to absolutely one entry, um, that you're down to one entry um, when you're in a circumstance where beforehand you had the same kind of selection rate as anyone else. I think that they're the most egregiously impacted, and those are going to be entry level jobs, right? And the administration has not been shy about what their real goal is for the H-1B program through the presidential proclamation and through the weighted lottery system. What they essentially want is to end H-1B use for entry level positions. They want that to be done because they allege, or they assert that the reason why college grads in the tech field can't find work is because all the work goes to H-1B holders, and that the H-1B holders that get these entry level jobs are standing in the way of American citizens from getting hired. It's an interesting theory because I think that most people, when faced with an opportunity to make a decision between hiring an American that you don't have to sponsor for a visa and a non-American that you do have to sponsor for a visa, I think people typically lead towards hiring the U.S. individual, all talent being considered equivalent. But that's not how the government views things. I think the government wants to get rid of, in as much a way as possible, entry level work for the H-1B. And so if you're an employer now and you do have a level one worker that's selected and approved eventually, I would not be shocked in the slightest if you were kind of put on a list for FDNS to look into for compliance issues, right? Because what they would want to do, and I'm using here is USCIS, what they want to do is kind of push this narrative that level one shouldn't even exist, right? Like you shouldn't be an entry level person on an H-1B, because if you're an entry level employee, you should, be hiring an American worker. That really does run counter to kind of the edict of what the H-1B was in place for, which is this entire notion that, we had kind of gaps and holes in our system that needed to be filled by international students. And it also created a pathway, right, where the United States was kind of able to operate under the benefit of brain drain, right? We're able to bring in students that want to go to our universities. They go to school here. We teach them up. And then rather than having them return to their countries where they're going to benefit those nations, we keep them here. And we give them this pipeline, right? We give them the path from the F1 to the H1 to potentially adjustment of status down the road. I think that there is a desire to kind of erode that pipeline by really muddying up the H-1B. And so what does that mean kind of long term over the next couple of years? If you're a foreign student and you're coming to study in the United States, I think it stands to reason that you want to have the option of being able to stay and work in the United States at the conclusion of your studies. If that pipeline gets drastically reduced or, almost eliminated to a point, I think it'll be a consideration that's taken when you choose where to go to school. Instead of going to the United States, maybe you're going to Australia or Canada or, Europe. So what I think that means is you're going to be put into a circumstance where you're going to see less people immigrating to the US to go to school because they feel the odds are going to be stacked against them for them to actually move here long term. I think you're also going to see generally, just kind of lowering in the desire of immigration to the United States if it hasn't already begun to occur. There's always going to be a pipeline of individuals that do want to come to the U.S. But at the same time, I think you may see a bit of a dwindling on high tier talent, on individuals that, think maybe it's a better option for me to go somewhere else, somewhere that's less restrictive with me being able to, get on a work visa in the future. And so I think for employers, they probably start kind of looking at their books and saying, what does this mean in terms of like, how much are we even going to bother to sponsor individuals at level 1 or level 2? Is it worth it to just go after, the high tier talent, or do we still, sponsor those lower salaried individuals as well? And like I kind of said, which I know this is kind of going to get back to being the ethos of the conversation, I just really do think it's going to lead to a reduction in the number of people that are actually registering. I would love to be wrong, but the truth of the matter is it would really shock me if companies were still willing to register at the same level that they did even last year, understanding what we know now, 1 year post administration, and how the lottery is going to work and how you're basically now barred from bringing in a foreign national on an H-1B unless you're willing to pony up $100,000.
Right. And I mean, H1B fee has always been rising. And do you think $100,000 fee is going to be the last limit?
Um, I think for now the $100,000 fee it's doing its job, right? So the Chamber of Commerce filed a lawsuit in back at the end of last year, basically challenging the applicability of the fee, whether or not it was valid, because it revolves around the Section 212F. Um, that lawsuit was ruled for DHS at the end of last year, which means that as of now, there is only one ruling in a court on this that basically says the president can do whatever he wants in relation to immigration matters for individuals that are coming into the United States. So they have appealed that on a fast track to the Court of Appeals because they've argued that it's a necessary fast track appeal because it's going to directly impact how people are registered in the lottery. So we're going to have to wait and see how that goes. If the appeals court upholds the lower court's ruling, we're going to go through a scenario where the lottery this year will have to have the $100,000 fee factored in. And like I said repeatedly, that's going to lower the number of people that are sponsored. It just is. And it's going to prioritize, which there's already been a prioritization, but it's only going to crystallize the prioritization of individuals that are already inside the United States. Now, where the $100,000 fee has become potentially its most nefarious, in my opinion, is that it is now, according to USCIS, applicable to individuals that are in the United States if they are found to be out of status or have failed to maintain status at the time of filing. So what that means, and I'm not going to be shocked at all when this is rolled out because the writing is completely on the wall for it. What that means is I'm going to guarantee that you will see DHS seek to find infractions in individuals' prior status, regardless of materiality of that or the severity of that. They will attempt to procure data that shows an infraction was committed, right? If they can claim an infraction was committed, they can then subsequently say that the individual failed to maintain status. Individual failed to maintain status, they are subject to the $100,000 proclamation fee. So that means even people in the United States who are chosen and file for a change of status, could still possibly have to pay the $100,000 fee in the event that USCIS concludes that they failed to maintain status. So what does failure to maintain status look like? And let's talk about the most common visa for the transition to H-1B, which would be the F-1, right? F-1 has full course of study. You have to prove that you actually, maintained your schooling, work authorization, OPT. Did you work at a valid employer? Did you work 20 hours? Did you work related to your degree? Did you not go over the number of unemployment days? STEM OPT employment, which I think is going to be the most targeted one during this year's change of status period. Did your company comply with the I-983 training plan? And can USCIS show that they didn't in some way? And if they didn't, you failed to maintain status, you're subject to the $100,000 fee. So what I think you'll see is you'll see that employed by USCIS, and you'll probably see more pushback against that through litigation because of the way 212F is structured. There's not a very sound argument to claim its applicability to individuals already inside the United States, but they have already won in court once. So I'm sure they're going to be emboldened to extrapolate it as much as possible. So yeah, I kind of lost myself on that question, but yeah, that was kind of all I had to say on it.
Thank you so much for taking that up also. And Silvermine, thank you so much for joining us. Please do not forget to subscribe to our channel, all folks out there, especially ones who have commented. Thank you so much for joining us with your questions. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also check out Wasden Immigration Litigation. They're on LinkedIn as well. You can connect with attorney Justin Rivera. And if you have any questions that you need further assistance on, you can book a consultation with them. And Silvermine is asking, it's always fun training the foreign visa worker who's coming to take your job. Okay, that is a comment actually. And then we have DK who has also joined us. What will be the impact on level one and two for H-1B candidates with more and more companies looking to AI to complete some entry level task work now? What is your
Oh yeah,
expectation for the number? Yeah.
no, I mean I know. I mean the truth of the matter is it's like you're already kind of getting screwed by the system here in terms of the changes that have been made to the H-1B, while you're also staring down the fact that there's this automation push with AI to eliminate entry level positions anyway. Um, yeah, it's not good. To be blunt, I can't imagine people being super psyched in the tech sector that are graduating college and looking for entry level positions. So yeah, I mean, I think it's not great. I think specializing in AI would be great, for the moment. I know that there's been a huge surge in O1 filings for individuals with AI, unique AI experience, and that's probably going to be the way to go for the next, couple of years. But yeah, I don't think it's great. I mean, I'm not a prognosticator of the economy, nor should I be allowed to be, since I don't have, the necessary training or a degree in that field. But you could kind of see the writing on the wall here with the continued slow hiring numbers over the past couple of months, and understand that, when hiring slows down and layoffs improve, that's generally not good for workers, and it's probably going to be restrictive for the economy. No one's going to say recession because we've apparently decided that word has been banned from our lexicon. And it's not fundamentally true at present, but it's recession light, it's recession like, and it's never a good sign for, immigration when there becomes a bottleneck or a tightening up of available jobs. And if you combine that with a protectionist regime, right, an administration whose underlying goal is to kind of block the U.S. off and make it less reliant on immigration or even foreign institutions in general, you're going to see a circumstance where I think that people level one and level two candidates are kind of up a creek. They're not in a good spot. I think that, yeah, I mean, I would love to be proven wrong, and it would be really cool if all the companies filing up, in this upcoming year, just filed level one and level two for their new entry level talent rather than trying to game the system. But once I heard through the grapevine that there were big companies that had come out basically supporting the lottery and supporting the $100,000 fee, and all that, I realized like, no, these, the big guys are where they are, and they want to hoard the talent that they can hoard, right? And if that means being able to cut off access to other people, then so be it. So yeah, I think the people that are going to be most drastically impacted are going to be people coming out of college. I think already, I have clients who have told me, that their current existing employees, they're on projects where they're like, I gotta make sure we keep you on this project. Like, we got to do everything we can to stay on this project because it's barren out there, right? In terms of new project work available, it is not great, and there are now restrictions that are being um, more readily implemented by employers, where they're basically saying, we'll interview you, but if it gets to the point where you're saying you need some type of visa sponsorship, we don't really want to mess with that, because the climate is what the climate is, right? And so I think that as a result of that, yeah, I think it's going to be very hard for those individuals over the next year or two.
Absolutely. And thank you so much, DK, for your questions. He also has another interesting question, that is, what's your expectation for the number of entries for this year's lottery?
Uh, I mean, I truly would be shocked if we didn't see a drastic reduction in the number of people. I mean, I'm not sure off the top of my head if I can just Google how many H-1B lottery applications were last year. So I think, yeah, I think they said for the last year is 470,000. I would not be shocked if we saw that number drop below 300,000.
Whoa,
Because I
that's
just,
huge.
yeah, I just really, I mean, you really have to think about the fact of the matter that people outside the United States, I think it's going to be almost impossible for them to have a company agree to sponsor them at this point. It just doesn't really make sense for a company to be willing to put $100,000 on there on top of all the fees that they're going to pay to file for you. And the truth is if that you are that talented or needed, I think they're just going to push you into a new visa category. You have the O1, but you also have the L1, where if you have a company that has a foreign affiliate, they're probably going to be looking more closely at an L1A or an L1B, probably an L1B for a specialized individual. Tell them to do that 1 year of outside work, and then petition and have them come in on a different visa. And then once they're here in the U.S., maybe then they think about sponsoring them for an H-1B, so that they're not subject to the fee. But yeah, I think it's going to be a pretty drastic drop. I just wouldn't be surprised. From my talking with people in the business industry, the people that are out there that are actually the petitioners and stuff, they feel like they're in more of a, we're going to focus on the guys we got now, and we're going to maybe worry about expanding down the road type thing.
Thank you so much, Justin, for taking that up. And well, DK, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Well, we do have a lot more questions. And Justin, can you tell us maybe how can job titles be manipulated, to qualify for higher wage levels?
Yeah, so I mean, a thing that you can do with the H-1B is you pick what's called an SOC code. So that's a classification for the job position. There's a bunch of different SOC codes that are available for positions. So you could take one like a software developer and say, okay, that's 151132. That's a software developer. Let me see what this person's wages are paid. Oh, wow, this person for level 4 is paid $250,000. Well, what if I could put them in a different bucket? What if I could say that they're actually not a software developer, they're a computer systems analyst? By making them a computer systems analyst, I can then say, well, the level 4 wage for that is only 180,000. I can stomach that. Then you're able to move forward, and you submit the registration for the individual. So that's, in that way you can kind of manipulate it to try to lower the wage that the individual is being paid. Where does this become a problem? Well, USCIS is going to look at those job duties, and the job duties, if they're not reflective of the SOC code selected, can issue an RFE saying, how is this person, a computer systems analyst when it clearly appears that they're a software developer? So then it becomes incumbent on the petitioner to be trying to push back and, say, no, I picked the right bucket. This is how I picked the right bucket. Let's stretch that out with the way that this administration has been behaving, right? We know with certainty, because there's a year of data, that denials are up. We know that denials are becoming more egregious than even they were a year ago. It would not shock me if you saw them, USCIS, try to kind of whole cloth go after SOC codes that traditionally have lower wages. They'll probably have arguments triggered already. They'll say there's data available that says, this position actually doesn't require a bachelor's degree, based on what the SOC code is. So it wouldn't surprise me if that was something that they were already thinking about doing as a way to kind of block the manipulation system of it. Are people still going to try to manipulate the system? Absolutely, they will. And it'll just come down to whether or not they can get the case through USCIS. And so I think you'll probably see people try that get, denied, and you see people that, maybe get approved, and maybe down the road they end up getting site visited by FDNS. So time will tell, but there are ways to do that, and I don't necessarily call it. There is a difference between manipulation, meaning that you're basically like knowingly distorting information to help someone qualify for a lower wage position, and actually having the ability to verify that someone can be filed as, SOC code X, Y, or Z. And so it is a delicate balance. It's usually a balance that requires an attorney. And I promise you, a lot of people that are attempting to do this manipulation are not using attorneys. And what they're probably doing is filing on their own. And then when they get their nasty RFE, they bring it to an attorney to ask them to fix it. So will you possibly see manipulation? Yes, I think with almost absolute certainty. Will it be successful? Time will tell. We'll just have to see how DHS plans to combat that.
Right, for sure. And what about, if you shift places, say from Texas to California, how is it going to, affect, uh, the H-1B lottery chances, maybe if you're moving from Texas to California?
Well, California has some of the highest wages in the United States, right? I mean, traditionally for tech, California and Washington are the places where you're paying the most money, to make sure that you're paying the proper wage. I would argue if you're a person right now moving from Texas to California and your company's sponsoring you for the H-1B lottery, you might be pricing yourself out of the lottery. And that's just the truth of it. The wages are going to be lower in Texas, although they are higher in Austin specifically. But overall, I think that if you're moving somewhere that has a higher wage level, significantly higher wage level, you're likely depressing your probability of being chosen in the lottery.
Okay. Okay. Thank you so much, Justin, for taking that up. And how about remote work influencing H-1B selection, under a weighted system?
Well, again, that's going to be right location specific. So, does this guy live in middle of nowhere, Missouri? Because if he does, we can probably pop him up to a level 4 wage because it's going to be so depressed. It's maybe like 160,000. If he lives in New York City, probably can't do that, because the remote work will probably have to keep him at level 1 because the wage is so high. That's why, like, when it's very frustrating to have a conversation about H-1Bs with people that don't do it, like it is for any field that I'm sure if you're a quasi expert in, to talk to someone that's a layman. There's this idea of like, oh, the wages are being kept down or the wages are being made low by the H-1B, and it's like, well, there's an entire system that's implemented to make sure that that doesn't happen, right? And in that system, there are challenges such as ensuring a position even qualifies as level 1. Then there's geographical issues associated with that too, where you're basically saying, "Oh crap, it's cost prohibitive for us to even employ an individual in Palo Alto, California, or New York City, or Bellevue, Washington, because it's just too hard because of the wages." So there is a floor that exists that does kind of prevent a level of abuse from occurring, where that floor doesn't necessarily exist because it's an MSA dominated issue of where the person physically lives, is in remote work. So if someone is living in a state where wages are lower, I don't know, maybe just picking like Missouri, Wyoming, Alabama, those locations are probably going to have a higher opportunity to be sponsored for a higher wage level. And if that's because that person's living there and working remote, that could be of a benefit to them. Alternatively, I wonder if you have people, for example, that are on F1 that are maybe working on STEM OPT remotely for an employer in another state. Those employers may begin looking and saying, maybe we bring this person in, get rid of their remote work if it means that we can lower the amount of salary that we have to pay them. And obviously, these salaries are all going to be in the six figures, if not close to it, even for the entry level positions. But what you could see is, like, if they live in a small place and it's remote, the company might say, all right, cool, full steam ahead. if they live in a high populous area or somewhere that has high wages in the MSA, and the company is somewhere else in another MSA that can offer them the opportunity for a lower wage, they might cease their remote work and start bringing them in.
Okay, okay. For sure. And at this moment, Justin, I wanted to take up Rajendra's question. He's asking, is there any legal pathway for DHS or USCIS to impose a $100,000 H-1B filing fee without Congress, or it's rumor completely unrealistic under current law?
So, according to a court that ruled on the matter, it was legal. You had a lot of us, including myself, being beforehand saying that I did not believe it was legal in its current iteration. I thought at best the the proclamation would only be upheld to individuals who were entering the United States for the first time on H-1B, meaning they had never been in H-1B status before, and they had never been in H-1B status before, and they were, selected in the lottery and approved. That was my thought process of this is who this will impact. Based on that ruling from the last court, that's from the court, that's not the case. They're saying that it across the board is going to be applicable. Will that stand? We don't know. We have to wait on the Court of Appeals hearing, which is this month, and then the subsequent decision that they make, whether or not to kick the case back to the lower court or not. My hope continues to be that in its final iteration, the proclamation will only stand in a very specific and limited manner of only to first-time H-1Bs. I don't know if that's going to happen or not. We don't know. It's up to the court, and it's up to the arguments that are going to be made this month. My personally held opinion is it shouldn't be, but that clearly clashes with what current law is. And so for now, I can only go by what the current iteration of the law is, which is it's valid and it's legal.
I know it was really shocking for us as well, but it is happening. And so, Justin, it's just the beginning of this year. January must have been super busy for you, especially after the government was shut down for some time. Tell us about how heavy it got for you when got back to working and up until now with all these new updates.
Yeah, I mean, I think anybody that's doing this nowadays can tell you that, being an immigration attorney comes with a lot of hours. There's just a lot more work that's been created and generated in areas where it hadn't been as big a deal before. The consulates are insane, to be quite frank with you, particularly in India. I saw a question here about going for stamping. The best advice I can give you to go about going for stamping for the next 3 years is do not go. Don't leave. Stay in the United States. If you leave and you go to get a visa stamp, I need you to at least 20% in the back of your head think you're not coming back into the U.S. Because that's just the truth of it. People are being stopped now that interview at consulates that have any history of arrest whatsoever and being given a 221G, and they're told to submit the arrest documents, and then nothing happens. We have a lawsuit that we're getting ready to file with plaintiffs that are in this very boat, some of which have been waiting 7, 8, 10 months for their visas to be adjudicated. These are work-related visas in most instances, meaning that there are end dates in the validity period, which if these people can't get back in, well, then they lose the visa, they lose the H-1B validity period. Their company would have to apply for a new H-1B. And what does that mean now? It means there's a $100,000 fee. So that's being intentionally done by U.S. By DHS in collusion with the State Department to make sure that that happens. On top of that, you're now seeing the H-4, the removal of the H-4 work authorization for the auto renewal starting to play out in earnest as people who even filed 6 months ago aren't getting approvals. Now, it's not across the board. Some people are getting approvals, and that's great. But I know that it's not a fully across the board thing. So those are some things we're working with clients as well. There has been a big increase in, like I said at the top of the call, FDNS and HSI investigations, DOL audit investigations, and all kinds of matter of issues there. And then you have to deal with, the insanity that is USCIS as well. As a personal anecdotal story, I had a case that was timely submitted to USCIS. They received the case on January 30th. The case was due by February 2nd. So, we delivered the case. We thought, all right, cool. February 2nd comes and goes, case status page updates, case in process. We get a denial 2 days later saying the case was abandoned. Okay, so the case wasn't abandoned. We have proof, and we already emailed the premium unit to see what they're going to do. But it all kind of speaks to the overlying nefarious nature that we've started to see with DHS, and I think we're going to see only expand as we go through the next 3 years of this administration. It's going to be a lot. Be prepared. I cannot stress to you guys enough. I don't even give a crap anymore if you think you have a perfect immigration record. If you are traveling, if you are getting a visa stamp, if you are transferring employers, if you are changing status, and you're going through your company and you're not having any level of conversation or anything whatsoever with your, the legal representation for that company, talk to an attorney, look through your records, start to see what could possibly come up. Those of you that are going for your AOSs, you guys do not file those on your own. I don't care if it's family-based, employment-based, whatever. Get an attorney. The way that they are now looking through things for what they perceive to be fraud, or essentially making up ways to interpret fraud, is beyond troubling. And I think that people need legal representation when they're doing these things to ensure that they're getting their fair shake at the system. I have a case that we are actually responding to, in the next 2 weeks, where the notice that was issued legitimately does not legally hold up to scrutiny. And what I mean by that is the officer who drafted this, or the AI system, or whatever the hell they're using nowadays, is attempting to say that black is white. And when we're getting to that point where they are just fully throwing out assertions that are not grounded in fact or reality, and you are a normal everyday person who's having to read these notices, and you're not able to push back and say that's literally not legally true, then you have a serious problem. So yeah, work with attorneys, talk to attorneys, get attorneys involved on your cases, hopefully from the outset. I don't even care if it's with me. It can be with someone else. I don't care, but use an attorney. The amount of business that we unfortunately get because someone did something on their own and is now coming to us to try to fix it, late in the game, be that through a request for evidence, a notice of intent to deny, a notice of intent to revoke even, those things can be stopped beforehand. And that's why you use an attorney. And with that, I think I'll get off my soapbox and say thank you very much for having me. And I appreciate it. And I look forward to us having another call again in the near future.
Absolutely, Justin. Thank you so much for, being here with us, so patiently taking up each of our questions. And sorry about not being able to show my face much in today's session, but I do hope we did not, miss on the reason why we had this wonderful, informative show today on this very important topic. And friends, thank you each one of you for joining us. Don't forget to check out Attorney Justin Rivera from Wasden Immigration Litigation. You can check him out on LinkedIn, and also check out Wasden Immigration Litigation. Check us out as well. We are Immigration Talk Show. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Thank you once again, everyone, for joining us, and have a wonderful day.